The one I just mentioned. Okay.
This is it.
Now, under the law, Mr. Schrimper, if you are convicted of this offense and sentenced to prison, once you complete your prison term, post-release control, in this case, is optional, meaning that they could put you under that, but they don't have to. So it still is up to the parole authority, not the court. And if they do, as you know, they'll supervise you through a parole officer under term conditions they set. And if during that period of time you're being supervised and you fail to comply, they can return you to prison, make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a felony, then in addition to whatever sentence you could be given in the new case, that judge in that new case could also sentence you for committing that violation while under post-release control. In this case, to an additional period of 1 year, wherever time left on the period of post-release control, whichever is greater. If that occurred, that would have to be served, and secondly, the sentence in the new case. You understand that?
Yes.
Okay. Now, the charge in this case alleges that on or about March 23, 2021, in Highlands County, Ohio, you did knowingly cause, attempt to cause physical harm to Sergeant J.D. Adams, a peace officer as defined in ORC section 2935.01, while in commission of his official duties, a violation of 2903.13a. So that's the assault of a peace officer offense. Now, Mr. Schrimper, do you understand what it is that the state accuses you have done, when, where, and how they alleged you did it?
Yeah.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense you try to raise in trial, and possible outcomes of the trial with your attorney?
Yeah.
Are you satisfied with her advice and confidence in this matter?
Yeah.
Has anyone threatened you to get you to plead guilty here today?
No.
Now, the agreement states on page 2 in bold, about halfway down, there's a bold underlined sentence. This language, it does appear to have a couple of changes. It says, defendant shall enter plead guilty to the indictment. State defense recommend 6 months incarceration. It did say 12, that's been marked out, and a 6 has been written in below. And then the last part where it says state defense argue sentence is stricken out. So the agreement is, as I understand it, is that there's a plea of guilty and a recommendation from both parties to get 6 months incarceration. You understand that?
Yes.
Does anyone promise you anything other than that to get you to plead guilty?
No.
Now, under the law, the matter of sentence is not binding on the judge. So if you plead guilty, I don't have to follow that recommendation. I could decide to give you as much as 18 months if I thought that was appropriate under the evidence of the law. You understand that? You need to speak up.
Yes, Your Honor, I understand.
Okay, thank you. I see you nodding your head, but we're also recording the audio. And again, if whatever sentence is imposed, you understand you would be subject to getting an additional 1 year on the post-release control sanction as well. You understand that?
Yes.
Okay. Do you hold any license or certification from any state, agency, or commission for any job or occupation, profession?
Don't understand.
Well, like a nursing assistant or STNA or something like that from the state agency. Okay.
I don't have anything on that.
All right. Now, you have certain rights you must understand before I can accept the plea of guilty. First, you have the right to have an attorney. Ms. Hacker has been appointed to represent you in this matter, since you did not have the funds to hire your own attorney. Now, she wasn't appointed simply to work the case out, but to provide whatever defense might be available to you under the law that you would like her to provide. So, if you decide you don't want to plead guilty and she wants to defend against this case, she will continue to represent you, including a trial, if that's what you want. You understand that?
Yes.
Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Schrimper, in which 12 people will be selected from a group of citizens from Highland County who were summoned for jury duty on your trial. And after they were selected, and there would be 12 of those people who would be on the jury. Now, after they were selected, the evidence would be presented, then there would be instructions on the law from the judge, and then they would decide by unanimous verdict, meaning all 12 would have to agree, as to whether or not the state proved your guilt or proved beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, and waive means to give up your right to have a jury trial, and in that case, you have to call a court or bench trial, meaning instead of the jury hearing the evidence, it would be the judge who hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proving beyond reasonable doubt. You understand that?
Yes.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is witnesses against you have to come into court and testify in open court in front of you and your attorney and anyone else that might be present. After the prosecutor's done asking questions of the witness, then your attorney would have a right to ask the witness questions, and that's called cross-examination, the purpose of which is to try to bring out evidence that could help your side of the case. You understand that?
Yes.
Right, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court and testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, court issues a court order that's called a subpoena, and that forces those people who have been named in that subpoena come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
All right, Mr. Shrimper, in the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You make that decision, and if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it except with one exception. That is, if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, in the Constitution, Mr. Shrimper, you are presumed innocent until proven guilty by the state on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden of proof is on the state to prove that you are. And they must, in fact, under the law, you're not required to present any evidence in trial. You may, but you're not required to. Whether you do or not, the state will be required to produce such evidence that convinces the jury or the judge, depending upon which type of trial you'd like to have, of your guilt by proof beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Right now, you originally entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and exercised or revoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. A guilty plea admits the allegations in the indictment, admits that they're a crime, admits that you're the one who committed that crime, and that plea gives up all the rights that I've just described for you this morning, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty would waive or give up your right to have a jury or court trial, waive or give up your right to prosecution against you and cross-examine for your attorney, waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state, waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty, waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. You would also waive or give up any right to file an appeal that you think you could have had up until this point in the case. Now, if I sentence you the maximum sentence or under other certain circumstances, you can file an appeal. That would have to be filed in 30 days for sentencing and review filed. And finally, a plea of guilty subjects you to being sentenced immediately by the court, which is what's likely to happen here in this situation. Do you understand all of that?
Yes.
Mr. Shrimper, are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge or the possible penalties?
No.
You understand them?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Do you have any questions about the guilty plea, what it means, and what will happen if you enter that here today?
No.
Do you have any other questions you'd like to speak with Ms. Hackner about before we go any further?
No, Your Honor.
You have any questions about anything that I've explained to you here this morning?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this written plea agreement that we've just gone over here?
Yes, Your Honor.
Right, then as to the charge, which alleges that on or about March 23, 2021 in Highland County, Ohio, you did not only cause or attempt to cause physical harm to Sergeant J.D. Adams, a peace officer defined in ORC Section 2935.01 while in the commission of his official duties, violation Section 2903.13a, in charge of assault of a police officer, fourth degree felony, which carries a possible prison term between 6 and 18 months, fine of $5,000, and also subject you to be sentenced to an additional 1 year consecutive for committing this offense while under post-release control supervision. How do you plead?
Guilty.
Right, the court finds that on this date, open court, defendants advised all of his constitutional rights made the only intelligent voluntary waiver, the same pursuant to Criminal 11. Please accept it or file. Defendants found guilty of the offenses set forth in the indictment. The court will not order a pre-sentence investigation. There has been a joint recommended sentence, and given the nature of the events as well as the defense record, the court will not order a pre-sentence investigation. We'll still instead will proceed with sentencing. Mr. King, anything you'd like to say?
Only was contained in the plea agreement, Your Honor.
All right, Ms. Hatton?
Likewise, things that are contained within the plea agreement.
Mr. Shrimper, anything you'd like to say?
No, Your Honor.
And Mr. King, you did consult with Ms. Sergeant Adams about this disposition prior to the plea?
Yes, Your Honor.
Okay. All right, well, this is judgment order of the court then that the defendant being is hereby sentenced to the Correctional Reception Center in Warren, Ohio for a period of 6 months. And he is given credit, according to this, of 119 days to the rest of March 24th. It's been held since then. You agree with that date, Mr. Shrimper? That's the day you're taking custody?
Yes.
All right.
March 23rd.
Okay, well, they don't count the first day, they start, after 1 day, so 119 days of jail time credit. Now, it's also ordered that the defendant be sentenced to serve a period of 1 year for committing this offense under post-release control supervision, since his time remaining on that as of today is less than 1 year. And that must be served by law consecutively to the sentence that I've just imposed. You're also ordered to pay the court costs for judgment, grant, and execution order, and if you don't do that, Mr. Shrimper, then the court, well, first of all, the clerk, back after various means, include levy on bank accounts, wages, earnings, or other assets which you may have. If that doesn't collect it, then once you complete your prison term, not while you're in prison, but once you complete it, then the court could order you to do community service in this county and give you credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid. All right, is there anything further from counsel?
No, Your Honor.
All right, then Mr. Shrimper, you're remanded to custody, thank you. And I believe that completes the jail. So,
That's correct, Your Honor.
all right. Ms. Blankenship, then, if you would turn on your audio, please. All right, this is case number 21 CR 81, State of Ohio versus Amber Ray Blankenship. And you are Amber Ray Blankenship?
Right now, I gotta go get my take this real quick.
Hey, at the jail, you still have your audio on. You can turn it off or leave me, whatever. Thank you. All right. Now, this hearing is being conducted by Zoom. You're still in a treatment facility, or Mr. Blankenship?
Yes, I am.
All right.
St. Lucie from West Union.
Okay. All right, and her attorney is Captain Hapner, appearing by Zoom. Her office also appearing at the state is Assistant Prosecutor King by Zoom. And Ms. Hapner, you and your client are stipulating this hearing by Zoom rather than in person.
Yes, Your Honor.
You're in agreement with that, Ms. Blankenship?
Yes.
All right, Ms. Blankenship is charged with aggravated possession of fentanyl-related compound, a fifth-degree felony. This is final pretrial. Actually, it's set for tomorrow. We moved up to today, and a trial date of August 12th is currently scheduled. Now, Ms. Blankenship, I received a plea of guilty form for this case, and this is a 3-page document the prosecutor's office prepared, and I'll hold it up to the camera at the first page, and it has your name and case number there. Can you see that?
Yes.
Do you recognize that document?
Yes.
All right, then on page 3, there are signature lines. And there's a paragraph at the top, and then right below that, there's a sentence that reads, I entered this plea voluntarily, and it has a signature appears to be Amber Blankenship. And I'll hold that up. Is that your signature there next to my finger?
Yes.
And when did you sign this document, Ms. Blankenship?
Thursday.
All right, and where were you signing? At the facility?
I was at my misdemeanor court for McKenna.
Okay, so were you present with Ms. Hapner then when you signed it?
Yes.
Okay, and did she go over with you before you signed it, explain everything to you?
Yes. Yes, she did.
And did you understand that it was an agreement to plead guilty, which means that there's not going to be a trial, and the next step in the case would be a sentencing hearing?
Yes.
And do you think you had enough time to fully consider this matter before making this decision?
Yes, I did.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
Now, the agreement states that you are going to plead guilty to the charge of aggravated possession of a fentanyl-related compound under section 2925.11 of the Ohio Vice Code 853 felony. Further states that you understand that the maximum penalty for that if a prison term is imposed would be 12 months, the minimum would be 6. There would be a fine payable of up to $2,500 and possible license suspension of 6 months to 5 years. Do you understand that?
Yes.
Now, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
And are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No.
Now, under the law, Ms. Blankenship, if you should be sentenced to prison for this offense, once you complete that prison term, the adult parole authority could, at their option, place you under post-release control supervision for a period of up to 3 years, which means you would be supervised on the terms they set by a parole officer because the judge is involved with that. And if they decide during that period of time that you have violated those conditions, they can return you to prison to sanction you for that violation to an additional period up to 1/2 of the prison term imposed by the court. However, if you commit a new felony, then in addition to whatever sentence the judge in the new felony case would impose upon you, that judge could also sentence you in this for committing that offense under supervision in this case to an additional period of 1 year. Whatever time is left on the 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. Do you understand that?
Yes.
Right now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. That means instead of going to prison, you would be put under the supervision of a probation officer in the term set by the court for a period of up to 5 years. If during that period of time that you're being supervised, the probation department felt that you were not complying, then they would file a written notification of that to the court, serve a copy on you, and then you would be entitled to have a hearing, be represented by an attorney. If the outcome of that hearing was that you had failed to comply, then at that time, you could be sentenced to prison for a term of 12 months and fined $2,500. You understand that?
Yes.
Right now, the charge alleges that on or about September 24, 2020, in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, a fentanyl-related compound, in violation of Section 2925.11 of the Ohio Vice Code. And so that's the charge, a 5th-degree felony, and the penalties I just described. Now, Ms. Blankenship, do you understand the charge and possible penalties?
Yes.
You understand what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible offenses you could try to raise in trial, and possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with your advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to get you to plead guilty here today?
No.
Now, on page 2, there are a couple of sentences that were bold and underlined, and the bottom 2 sentences have been scratched out. And I'll read, first of all, I'll hold that up there and show you. Do you recognize the language there on page 2 of the plea agreement?
Yes.
All right, the part that's not been marked out, I will read, as it appears to be the substantive term of the plea agreement. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommends community control, and defendant be referred into drug court. Is that your understanding of the agreement?
Yes.
Does anyone promise you anything to get you to plead guilty here today other than this?
No.
Under the law, the matter of sentence is reserved to the judge, not the party. So even though both parties are recommending community control, I don't have to impose that sentence. Once I hear all the evidence, I think that's not the correct sentence. I could go ahead and sentence you to prison for between 6 and 12 months, fine you $2,500, and impose a license suspension of 6 months to 5 years. You understand that?
Yes.
Right now, in regard to the drug court, Ms. Blankenship, I'm not sure how much you're aware of that, but under the law, the judge does not order somebody to go to drug court. They have to apply for it. And the reason for that is it is more intensive and requires a lot more effort by people to apply. Regular community control is basically certain conditions that you are supposed to comply with, And if you do, then you don't have to go to prison, but if you violate it, then you could. But the purpose of that is basically to keep people out of prison. Now,
Right.
drug court is different. Drug court focuses on the person's substance use disorders and or mental health issues, and it is a much more intensive program. It requires people to be in counseling virtually every day for a fairly long period of time, several months. Also, you're subject to being tested every day. You have to call in every day at a certain time, and then if you are told you have to be tested, you have to report within a certain period of time, and if you fail to comply, then it will be sanctions issued. Now, the approach of drug court is for people who are interested in getting sober or staying sober and turning their lives around. So it requires a commitment from them. That's much greater than just simply saying, I'm going to not violate my conditions of probation. So, for that reason, you have to apply to be admitted to drug court. I don't think you applied yet.
Yeah, I had contacted Ms. Sturgill,
Okay.
and she was gonna get together with her.
All right, good. So you will have to fill out an application. Ms. Sturgill is going to go over everything with you. There are several pages of the program description handbook for people who are participating in the program that they must really read and sign and acknowledge and agree that this is what they want to do. But then at the sentencing hearing, then I'll decide whether or not, first of all, there's certain criteria you have to meet legally. Ms. Sturgill will have to evaluate you and inform you whether or not you meet those, in her opinion, meet those criteria. Not just legal, I make a decision on legal criteria, but on clinical criteria as well. And then once she makes her recommendation, then it's up to me to make a decision as to whether or not I think you will be admitted into drug court. So that's the process that we follow. You understand that?
Yes.
Okay. Now, do you hold any license or certification from any state agency or any type of a profession or occupation?
No.
Right, and you have rights you must understand before I can accept the guilty from you. First of all, you have right to counsel. Ms. Hackler was appointed to represent you. Now, her appointment wasn't simply to work the case out, but to provide any defense to you that might be available under the law, which you wish to provide. So, if you decide you don't want to do this, you're still going to be represented by counsel. She'll defend you throughout the case, including a trial, if that's what you want. You understand that?
Yes.
Right, under the Constitution, we have a right to a jury trial. In this matter, in which 12 people would be selected from a group of citizens of this county that were summoned for jury duty under the trial date. After they were selected, the evidence would be presented, they'd be instructed on the law of the judge, and then they would decide by unanimous verdict between all 12 have to agree whether the state proved your guilt or proved beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and in that case, you would have what's called a court bench trial, meaning the judge would be the one instead of the jury that would hear the evidence, apply the law, and decide whether or not the state proved your guilt or proved beyond a reasonable doubt. You understand that?
Yes.
Right now, under the Constitution of the Plaintiff, you have a right to confront witnesses against you and cross-examine for your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes.
Right now, under the Constitution, you have a right to use the power of the court to require or compel witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request for issues of court orders called subpoena, and that would force those witnesses come to court to be able to testify if you want them to, though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination. And that means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about it except in one situation, and that is if there's a jury trial and you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, in the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to prove you're not guilty. The burden of proof is upon the state to prove that you are. In fact, under the law, you're not required to present any evidence at trial. You may, but you're not required to. Whether you present evidence or not, the burden will remain upon the state to prove your guilt, prove beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Right now, under the Constitution, when you entered a plea of not guilty, you denied the allegations in the indictment, denied you committed any crime, and you exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. That plea waives gives up all the rights that I described for you this morning, except your right to have an attorney, because you always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty, waives gives up your right to a jury or court trial. Waives gives up the right to confront witnesses against you and cross-examine for your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, same as the state. It waives gives up your privilege of self-incrimination, because if you say you're guilty, that's what you find you guilty. It waives gives up the presumption of innocence, because if you say you're guilty, the state's not required to prove that you're guilty. It also subjects you to being sentenced immediately by the court, and finally, it waives gives up any right to file an appeal that you think you could have had in this case up until this point in the case. Now, if I were to sentence you to the maximum sentence or under certain circumstances, you can file an appeal. Any appeal that you want to file will have to be filed within 30 days from sentencing if you're being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
All right, now, Ms. Blankenship, do you have any questions about the charge and possible penalties?
No.
Do you understand?
Yes.
Have any questions about the plea agreement?
No.
Do you understand?
Yes.
Do you have any questions about the constitutional rights of the claim?
No.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty and what the consequences of that plea will be if you enter here today?
No.
Do you understand?
Yes.
Is there anything you'd like to speak to Ms. Hatner about before we go any further in the case?
No.
Do you have any questions about anything I've explained to you here this morning?
No.
All right, then Ms. Blankenship, is it your decision to withdraw your non-guilty plea guilty to the charge pursuant to the terms of the written plea agreement that we've just gone over?
Yes.
Then as to the charge which alleges that on or about September 24, 2020 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with a fentanyl-related compound in violation of Section 2925.11 of the Ohio Revised Code. The charge of aggravated possession of fentanyl-related compound, a fifth-degree felony, carrying possible prison term of 26 to 12 months, fine up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. Court finds that on this day in open court, the defendant was advised of all her constitutional rights, made a knowing, intelligent, voluntary waiver of the same. Pursuant to Criminal Rule 11, the plea is accepted and ordered filed. The defendant is found guilty of the offenses set forth in the indictment. The court will order a pre-sentence investigation, including an assessment for substance use disorder, treatment, and/or mental health. The case is referred to the drug court. Ms. Sturgill is actually on the hearing now. And you have a possible completion date yet at St. Lucy's?
I'm actually completed inpatient. I am now in transitional living.
Okay.
And I can stay here up to a year if I want.
So you don't have any plans to immediately be moving anywhere else?
No.
All right. Because if you're going to be a drug court, that's something that you'll need to talk with the treatment team about. So, all right.
Okay.
We'll set this for sentencing on September the 1st at 9 a.m.
Okay.
And we can still do that by Zoom if that is agreeable to you and your attorney. Ms. Sturgill, do you want her to call you or set up an interview, or what do you want her to do?
Yes, I actually did reach out last week to try to make contact with the case manager. I have not heard back yet, so if you could have your case manager, get with me, that would be great.
Okay.
All right. Anything further from council?
No, Your
No,
Honor.
Your Honor.
All right, September the 1st at 9 AM, and again, we can do that by Zoom.
Okay,
All right.
thank you.
Conclude hearing, then, thank you.
Thank you.
Okay. Mother.